I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I am dropping on you number 75 from our compilation list. We will be in 3 different judges' courtrooms. Today will be one of those days where it will be Sovereign Citizens Hall of Fame with some sprinkles on top, meaning we have a non-sovereign citizen proceeding in the midst of this, and we're going to be in 3 different judges' courtrooms, all 3 judges out of the state of Michigan. Before I give you their names, just know there will be no commentary at the end of this compilation. Chapters will be added for your convenience. Continue to like, share, comment, subscribe, all of those good things. It is really a help to the channel. Now, the judges' courtrooms that we're going to be in on today. First, we will be in the courtroom of Judge Lisa Babcock out of the state of Michigan. Second, we will be in the courtroom of Magistrate Hillary Braley, also out of the state of Michigan. And last but not least, for our non-sovereign citizen case, we will be in the famous courtroom of Judge Brian Oakley. And you know, once that name is mentioned, there's going to be some fireworks involved in this proceeding. I appreciate you guys as always for joining me for these compilations. And listen, let's go ahead and jump into number 75.
Good afternoon. All right, we are on the record in the matter of People versus Latavis Trashad Thornton. This is case 25-203-FY, and may I have appearances for the record, please?
George and on behalf of the people, Your Honor.
Thank you. And?
I'm Melissa Vachon with the Office of the Public Defender, Your Honor. I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
Okay. And Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavis Trashad Thornton, which is the nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like it's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn, okay? But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable, okay?
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir.
Mr. A?
Mr. Thornton. So if you want to appeal,
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavis Trashad Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But yes, there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, I mean, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton. So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a 6th Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. Well, no, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail, okay? So,
can I please?
Because here's the thing. I don't want to be disrespectful to you.
Right, absolutely.
I know it feels disrespectful, but here's why. Here's my concern. I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm fine with you doing most of it. But please, to protect my free speech, could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just simply let me know? And
okay.
I am aware that I am innocent until proven guilty, and that something I say could, like you said, come back and haunt me. I'm well aware of that for the Magistrate Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent, unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Saturday. Saturday is going to happen. Unless means we don't know what's going to happen. And in your case, we don't know what's going to happen. You haven't seen the evidence. Okay, I'm going to keep going through this, and then I'll acknowledge you in just a minute. You haven't seen the evidence.
Okay.
No attorney has seen the evidence. The court hasn't seen the evidence. So you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at trial. And now I'm going to read the charges against you because you have a right to know them. Okay, you can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for. No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you get to reading, can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor, and based as far and that is why I feel it necessary for me to make certain things known for Latavius Treshaw Thornton, for that the script can so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Latavius Treshaw Thornton to the courts. That's I have those full intentions. And so that you guys can be safe from all liability of Latavius Treshaw Thornton as his representation. That is the only reason why I speak in the way of please refrain from calling me Mr. Thornton and certain things, because it's pertinent for you guys to know I've already been treated as the surety. I am not the surety. I'm really shoulders. Like, if you guys meet my people, you will find out I'm really shoulders. Latavius Treshaw Thornton is really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. So with that information, I understand that the script goes a little different, and I understand that. I understand me now. I have the right to let it be known that I'm not the surety, and nobody has. I'm sorry. And
okay. All right.
Yes,
So
ma'am.
here's
Your Honor.
here's the thing. That's okay. That's not an issue. So here's the thing. I don't know if you remember when a guy named Mitt Romney was running for president some time ago, and he said, and he really upset people with this. He said, "Corporations are people, my friend." And a lot of people made fun of him, but corporations are people. So that LLC would be a person in the eyes of the law, but a person does not become an LLC. But regardless, I'm going to read these charges because you have a right to know them. So in count 1, you are accused of police officer assaulting, resisting, and obstructing. And the specific allegation is that on or about March 9th, 2025, at Carey Street and Lake Lansing Road in the city of Lansing, zip code 48912, you did assault, batter, wound, resist, obstruct, oppose, or endanger Kayla Bevere, a police officer with the East Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is a felony, punishable by up to 2 years in prison and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. In count 2, you are accused of assaulting, resisting, or obstructing a police officer, again, on or about March 9th, 2025, at Carey Street and Lake Lansing in the city of Lansing, zip code 48912. Specific allegation is that you did assault, batter, wound, resist, obstruct, oppose, or endanger Chris Shattuck, a police officer with the East Lansing Police Department that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is, again, a felony, punishable by up to 2 years in prison and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. Lastly, in count 3, you are accused of, again, assaulting, resisting, or obstructing a police officer. And the specific allegation is that on or about March 9, 2025, at Carey Street and Lake Lansing Road in the city of Lansing, zip code 48912, you did assault, batter, wound, resist, obstruct, oppose, or endanger Colin Lemire, a police officer with the East Lansing Police Department, that you knew or had reason to know was performing his or her duties, contrary to MCL 750.81D1. This is, again, a felony, punishable by up to 2 years in prison and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. And this is alleged against the peace and dignity of the people of the state of Michigan. Now, we're going to talk about your rights. You have the right to an attorney, and today, Attorney Vachon is standing by. If you can't afford an attorney, the court will provide one for you, and we have superb public defenders in this court. That said, you can hire any attorney you wish. You would have to pay them, but you could choose whomever you wish. Now, there is an option for you to represent yourself, and we'll talk about that more at a future court hearing, okay? You have the right, as this case goes forward, to have these charges heard at a trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence, and you could question any witnesses the prosecutor called. You could call your own witnesses, and if they didn't want to appear, the court could issue a subpoena, and the court could make them appear. At a trial, you could testify on your own behalf, or you could remain silent. And if you remain silent, no one could use that silence against you. At a trial, you could bring any evidence you wished, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. And perhaps most importantly, and you know this one, this is your Fifth Amendment to the Constitution, you have a right against self-incrimination. And that means no one can do anything that forces you or tricks you into making yourself guilty. Now, how do you wish to plead?
I don't. You said a lot, so can I address them part for part first?
No, not right now. So here's what I'm gonna do. Here's what I'm gonna enter. I'm gonna enter a not guilty plea on your behalf, and here's why.
Can I ask you this first before you enter that plea? If me giving you a plea right now, will that be in response to everything that you just said?
Nope. So a plea would have you pleading. Would have you pleading guilty to all those charges. We've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes, 3 felonies, without having seen the evidence against you. So you can stand mute and the court enters a not guilty plea, or you can say you want to plead not guilty and you would be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider it. And I think that's what you want to do, because that is your hard-fought constitutional right, among other things.
It's a bit more to it, Your Honor. That's the issue. So based off of the things that you stated, that's not what my understanding is. From my understanding is I was attacked by some people and I was protecting.
Sir, I know you don't want my representation, but I would advise.
No, ma'am.
I would advise that you not talk about anything that happened.
Please don't, ma'am. I appreciate that. I'm aware of why you're doing that, but I'm aware. Like I said, me and the judge, I told her something that I might say could come back to haunt me. I'm already aware of that. So thank you so much, Miss Melissa, but please do not intervene. But once again, back to you, Your Honor. From my understanding, I was assaulted, and I am shoulders. Once again, I have never told anyone. I don't want you to mute me, Judge. This is going back to this situation. Okay, thank you. I never told anyone that I am Latavius Trayshawn Thornton. Not one time. I have reiterated. I am shoulders, Latavius Trayshawn. Not just to you, Your Honor. That's so to be redundant for the record. Okay. I have reiterated that Latavius Trayshawn Thornton is a nonprofit organization. I am not a surety. I am shoulders. I am appointed to be an administrator for Latavius Trayshawn Thornton. No, that's why I'm here, but not a surety for Latavius Trayshawn Thornton. Furthermore, Your Honor, my understanding is I was attacked and assaulted, and I'm not sure if I could let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from all the evidence that they have gathered. I would like to use it in my assault case against East Lansing Police Department and its agencies.
Okay, so we have a couple different options here. First, The court is going to enter a not guilty plea on your behalf, so you can pursue that at a hearing where we can bring in evidence and that sort of thing, okay? Secondly, you have other options. You can also, you could investigate a civil suit against the City of East Lansing Police Department. There's a police oversight commission. So those are still available to you. Right now, I'm going to enter a not guilty plea so you can get the evidence to proceed. All right. Now, next up, we have some dates when you're going to return to court. And let me just pull those up here. Okay, we're done. Okay, go ahead.
Yes, I just wanted to speak on my previous court history and let you know why it may look the way it looks.
Okay, no, here's the thing. I'm going to ask you to not say anything because I don't want to accidentally become biased.
Gotcha.
So, all right, so here are the dates. All right, you're going to come back for a probable cause conference at 8:30 a.m. March 21st. Now you're going to get this in writing, okay? 8:30 March 21st, and a preliminary exam. You're going to get this in writing too at 9 a.m. March 27th. Now, my best advice would be to speak with Attorney Vachon because she can explain how you pursue those things. Now, we're going to move on for a moment to bond.
It kind of broke up at the end. I didn't hear what you said. I'm sorry.
Okay, we're going to move on to bond or bail. So would you like to be released on bond or bail?
Could you explain the difference to me, please?
Your Honor, I was going to ask for a bond. People
okay. We're going to let Mr. Anid go first. All right, Mr. Anid.
You know, the people are looking at MCL 765.6, some of the factors to
now
consider.
You're cutting out. I'm sorry, go ahead.
Okay, if you said something like that, would it make you biased? Couldn't you be speaking to make you biased?
Well, I'm going to come back to you in just a minute, okay?
Okay, no problem.
All right, Mr. Nid, I'm sorry you were cutting out, but please.
Your Honor, the people are looking at some of the factors to consider bond. The people are asking for at least a $25,000 cash surety and GPS tether if he does post bond. We're looking at the seriousness of the offense charge, the protection of the public, the previous criminal record, and the dangers of the person accused, the probability or improbability of the person accused appearing at trial of the cause. All those factors are not in favor of the defendant, Your Honor. He failed to appear for sentencing in, I believe, circuit court. And again, Your Honor, if the court has updated lien, if you can see if he has a warrant from a couple years back, that's for pleading for attempted resisting and obstructing, is what my note indicates. Protection of the public, Your Honor. This case involves assault on officers. I think one officer got punched in the face. The previous criminal record, he has 4 criminal histories from 4 different states, Your Honor, pending from.
Okay, no, he's going to get, and then I'll hear from you, okay?
And his probably. Your Honor, lastly, he failed to appear for several years on sentencing. He's not going to appear for this case if he gets released. I just asked for a high bond and a GPS tether if he posts that bond. There's a lot of risk to the public in this case. And he obviously he has ties to Indiana, Kentucky, Georgia, and one other state, Your Honor. This is a problem.
Okay.
Thank you.
Okay, now.
Before we get to the bond,
okay, I'm going to give you a chance, but here's the thing. Because there are certain key words, because there are specific things attorneys ask for, do you want Attorney Vachon to address this on your behalf? Because she's really good at this. I will tell you, she's really good at this.
Can I say some things to Attorney Vachon before I make that determination? Right.
Yes, Your Honor. Could we take a brief recess and I could have a breakout room?
Okay, so you're going to be in a breakout room with just Attorney Vachon, then we're going to come back. Nobody's going anywhere until after you've had a chance to come back, okay? One moment, please. Okay. We'll put you in a breakout room. Thank you.
Thank you.
Judge, you are also muted. Oh, both of you are unmuted.
Now we're unmuted. Mr. Anid, are you coming back?
Yes, Judge.
Okay, so I'm going to start with Mr. Anid has spoken. I'm going to start with Attorney Vachon. Attorney Vachon, anything from the breakout room?
No, Your Honor. The defendant will speak for himself.
Whoa.
Okay. Sir, please proceed.
Okay, Your Honor, thank you. Mr. Thornton is not a flight risk for, he has multiple properties in the Michigan and the Lansing area that keeps him here. Also, he has a lot of things he do here. He's a coach for 4th grade, 5th grade, 6th grade basketball teams, and they play year round. He's also a mentor to young children and to people who have had traumatic situations. They call on a daily. He's a counselor to the community and to the public. Furthermore, he's not a danger to the community or based off of his innocence, and he's not a threat to anyone in the society. He is actually beneficial to Mr. Thornton is actually a beneficial role in the community, and kids and multiple different areas of people, they look up to Mr. Thornton, and they will attest to his character as an upstanding, nonviolent, peaceful individual who brings smiles and love to the community. And he, once again, may I reiterate, is not a flight risk. Yes, he has ties to other places, but those ties are not as pertinent as to the ties of where he originally was born and reside and has grown as a part of this community and in a very effective way.
Okay, thank you. That's very well said. Sounds like Mr. Thornton really has a lot of good qualities. Okay, so I am looking at the file, and I want you to bear with me a bit. There was a song when I was younger. When I was in high school, there was a popular song that said, "Cruel to be kind." Okay, so I'm looking at this, Mr. Thornton, and there's a warrant out of 30th Circuit Court, downtown, East Lansing. Okay?
Yes.
And this is from 2022. And it's a statewide pickup, no bond with extradition. So here's what I'm going to do. I'm going to come back to that in just a minute. I'm going to set a money bond of $10,000 because all of the days that you don't post that bond, you will get credit for the time. If I gave you a cash bond, what would happen is Ingham County would pick you up on this old warrant and hold you until that case was resolved. By setting a cash bond on this, you get credit for the days you're in. Then, when that's resolved or close to being resolved, I will reconsider the bond amount. We call that making a bond motion, and I'll entertain that. But right now, this is cruel to be kind, okay? I know it's not what you want, but having been around the law long enough, this means they're going to keep you in custody for some time. So I want to be sure that you get something for it. Now, I'm going to put some other conditions on the bond for when you're able to bond out. And you're going to get these in writing, but I need to read them to you, and they need to be part of this record. So if you want to appeal, it's all here for you so they can evaluate whether I did this right or not. So number one, if you post bond, you may not leave the state of Michigan without prior permission from this court. Number two, you are presumed innocent, but the court says we have to tell you this right now. You may not commit any crime while released. Doesn't mean I think you're going to, but you have a right to know that. Number three, you must immediately notify this court in writing of any change of address or telephone number. Then you must not use alcohol, recreational marijuana, or any illegal controlled substance. If you have any medications, you must take all medications as prescribed. Do you have a medical marijuana card, sir?
I'm sorry?
Do you have a medical marijuana card?
Mr. Thornton does not know.
Okay, so may not use marijuana at any time and may not apply for a medical marijuana card without prior permission from this court. May not possess or purchase a firearm or other dangerous weapon. May not use any object as a weapon. may not engage in any harassing, violent, threatening, or stalking behavior toward anyone, may not have any contact with Kayla Bevere, Chris Shattuck, or Colin Lemire, can't use have anyone else contact them, can't use any social media to look them up or try to contact them. Okay?
I don't have social media.
All right, now, you must contact pretrial services by 4 p.m. on the day you're released from custody. All right, anything further, Attorney Vachon?
No, Your Honor.
Smith. Okay, anything further, Attorney Annette?
Yeah, so I must have misheard. Was there a dollar amount to the cash farm?
10,000.
10,000 cash charity?
Yes, sir.
Thank you. And then lastly, was the GPS ordered if he was released? If not,
That's not necessary.
No,
I have
okay.
children.
Just a minute. All right. I'm just going to answer his question. No, I'm looking at the circuit court bond, which, no, it was not. Okay. Now, sir, what would you like to say?
First and foremost, how much you said that for each day that the bond isn't posted, there would be a credit amount. I just want to throw this out there for Latavius Thornton. Once again, he accepts that offer for the credit amount to be $1,000 a day, and furthermore, he accepts other offers from the prosecuting attorney's office if they are willing to go day by day with Mr. Thornton, if he's incarcerated.
Well, that's good to know, but that's not on the table just yet, okay? And so what happens is you get credit for time in this case with that bond amount. Otherwise, if I were to give you what's called a PR bond to say you can go, then you wouldn't get any credit for this time while you're waiting for that old case to be resolved. So, okay, so you're going to receive all of this in writing, and we will see you back 8:30 a.m. March 21st. Okay, and you want to discuss with Attorney Vachon what a probable cause conference, or Attorney Foreman.
Your Honor.
Yes, ma'am.
There was no application for public defender submitted. So at this time, there will be no counsel with him. Now, if Mr. Thornton changes his mind at any point, he can always apply for the public defender's office. But at this point, I'm unable to submit an application for an attorney.
Okay. Well, I would just ask you to consider. Here's the thing. You can apply for it and turn it down later. But if you don't apply, it can stretch things out a lot longer, and you don't want that. Just worth considering. You make your own decision. You certainly have every right to make your own decision, but I would just, if my beloved baby nephew, who's not a baby, he's about your age, we're in this situation, that's what I'd suggest to him, okay? All right, that is all for this record. Thank you.
Now calling case number 24W001656. This is the Township of Ypsilanti versus Shannon Phillips.
Hi,
Hi, can you state your name for the record, please?
Shannon Phillips.
Okay, thank you very much. So today is the date and time set for an arraignment in this matter. What I have here is a citation from May 27th of 2024 that charges that on or about that date you did operate a motor vehicle on E-Course Road at or near Harris Road with improper plates. It says that the plate did not come back to the vehicle that it was on. That is a misdemeanor with a maximum penalty of up to 90 days in jail, a $500 fine with court costs, or both. Do you understand all that?
No, I do not understand.
Okay. So let me clarify. When I ask if you understand, what I want to know is, do you know now what you are being charged with, whether or not you agree with it?
No, I do not agree with it. And I filed
Okay.
paperwork to the court
Yes.
expressing that.
Okay, and I'm cutting you off for a second because I'm not asking if you agree with it. I'm just asking. I have explained that you're being charged with having improper plates. Do you understand that that is what you are being charged with? Again, I'm not asking if you agree with it. I just want to make sure, because the purpose of this hearing is to determine whether or not you are competent to stand trial. That's part of it, at least. Do you know what you are being charged with now?
Yeah, I see it on the paper.
You do have the right to remain silent because anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings. You do not have to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if these proceedings would have any effect on your citizenship status. If that does not apply to you, then do not worry about it. So, do you wish to have the public defender speak on your behalf?
No.
Okay. In regards to the misdemeanor charge against you, how are you pleading at this time? Or are you standing mute?
Standing mute.
Okay. I am going to set this for a...
Ma'am,
Yes.
this has been long and drawn out since, May. I don't even have that vehicle anymore. Unfortunately, I've had to buy 2 vehicles since that vehicle. Not to mention how aggressive and threatening your officers was when they approached my vehicle. Not to mention they were pulling on my door, yelling and screaming for me to get out, or they were going to pull me out. I do have that video on my phone. However, because my laptop is not working, I have to use my phone.
Okay. Before you continue, couple of things. One, I will note that the officers are not court employees, so they are not the court's officers. What I am going to do, because it is the next step in this process, is set you for a pretrial. Okay, the purpose of the hearing today is to make sure that you know what you're being charged with and what the potential penalties are. The next step is a pretrial, which is where you will get to discuss with the judge more of what happened that day, and if you have evidence, then you can bring it up then. Your pretrial is being scheduled for November 27th.
Just a waste of time. 11/27.
Correct. This year, so that's 11/27,
Mhm.
2024. That will be at 9 in the morning over Zoom before Judge Washington. Because of your appearance here today, I am recalling the bench warrant that issued for your arrest on October 9th. That bench warrant had issued because of failure to appear for a number of arraignment dates that were set.
But
So
I was there and I have proof of that as well. I was on the hearing. It did the same thing it was doing now, saying that the host was there and would let me in. But I sat there for over like 2 hours on the 9th and the 10th and wasn't let inside the Zoom on either day. I do have screenshots of that, so I'll present that as well
Okay.
at the next hearing.
Okay. So to be clear, the bench warrant is being recalled, so that is going away.
Thank you.
The court is setting a personal recognizance bond, so basically you're promising to appear for the next court date. Again, that's November 27th. I will note that sometimes, depending on the size of the docket, it can take a long time. And I think what was my arraignment docket last Wednesday took 3.5 hours. So it can take a long time. So long as you're seeing the message that the Zoom is still going on and that the host knows you're there and can let you in, then as much as it is not a whole lot of fun, you should wait.
Okay.
Okay. So, do you have any questions right now?
Not at the moment. I don't believe so, no.
Okay, thank you. So your next court date again, November 27th, 2024, 9 in the morning over Zoom before Judge Washington.
Okay.
All right, appearances for People versus Littleton.
Morning, Honorable Seth Moore, on behalf of the people, 84724. Good morning, Your Honor, Attorney Scott Cross and Attorney Martin James Case, hearing on behalf of Mr. Littleton. Mr. Littleton, can you please introduce your
All right, ladies, we ready to go?
Yes, Judge, the people are ready to go, and I have a complaining witness who flew in from out of this country to be here today.
All right, put her on the stand.
Your Honor, if I may, Mr. Littleton, to refer the competency at this time, the defense counsel is adamant that Mr. Littleton is no way understanding the nature or the object of the proceeding and cannot. He is not fully aware, Your Honor, when I try to ask him, or explain to him that I'm his attorney. He doesn't.
Let me stop you. When did you talk to him and realize you had those problems?
Well, it's been a compounded conversation. So it was the first one with the PCC. It was a little off. If Your Honor was, I'm not sure if Your Honor was the judge at that time.
Was not.
That I didn't think any.
Counsel, my question was a simple one. When did you know you had this problem?
So I'm telling you, it's a compounded issue, Your Honor. It wasn't just the first time, it was the second time also.
Denied. Denied. Twice I've asked you a direct question, you can't answer it. No, I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today. I didn't ask for an argument, counsel. I just told you my decision.
Going to be completely, I think to be ready and what to be Mr. Wilson had no opportunity to review the discovery. I'm not the attorney of record.
Then why are you here? Who's the attorney of record?
And that is correct, Judge, as much as Ms.
So schedule a show cause for Attorney King for contempt of court. Would somebody like to explain to me why the attorney of record is not here for a scheduled exam?
Understanding when there is a different matter that he's explaining to us because I was going to come here anyway, and because Mr. Littleton was going to refer to competence.
No, he wasn't. No, he wasn't. You were going to ask for that.
The court, the statute requires that the court at least consider that the referral to competency at this point in time juncture. I understand that there has been a delay in the complaints from out of the country. However, the statute is very clear, and if Mr. Littleton cannot assist rationally, cannot comprehend what is actually happening, actually he cannot move forward. And I think the court has an obligation to consider.
Here's what I consider. Here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled, that don't show, don't call, just ghost us. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench. Is that clear? We've been told we have to actually hold you people in contempt so that they can withhold the payment for the job that you're not doing. Would you like to say anything?
Judge, I just asked for an opportunity to make a fair record, if I may.
Go ahead.
So first of all, I would like to note that this is my first time actually working with Ms. Barrage. This is not, I believe, her choice. I believe she was sent here by Mr. King.
Oh, it sounds like they threw her to the wolves.
I just want to acknowledge that. I don't think that this is a problem for me.
No, she's just lucky enough to be the one I yell at. No.
Judge, I contacted Mr. King. I called NDS last week, contacted them specifically so that I could figure out ahead of the PCC who the defense attorney was. I found out that it was Mr. King. I contacted Mr. King. I got a hold of him that day. It was the day before the probable cause conference. I let him know that I was personally sending him the digital discoveries so that he could review it. I indicated that there may be some competency concerns, and I asked if he would let me know if he would be referring for competency. I also let him know that I spoke to the out of the country complaining witness, confirmed the next 4 to 6 Wednesdays her free in her schedule, and let him know that we would be flying her in, and told Mr. King that I would make any of those days work, but that if we scheduled an exam for her to be flown into the country, and Judge, this is very important, this happened at the airport, so flown into the airport that she was sexually assaulted in, that if that happened and if she came here, we were holding this exam. Because I was not going to have the victim come all the way back here, only to be told that there was an adjournment request or have him be referred for competency. I asked Mr. King that. I did feel at the time like he was dismissing me, but I also recognized it was pre-PCC. The PCC happened. I appeared early. I was not present when the actual date was set. It was set for 7 days out. We did everything that we could to get the victim here. I had the officer in charge meet her where her plane landed at the actual gate to get her from the gate through the airport. Again, she was sexually assaulted into her hotel to keep her calm because she's been extremely traumatized as a result of this. Prior to this, after all the arrangements were made, I started calling Mr. King 48 hours before the victim needed to leave to come here, just to confirm that he was not planning on asking for an adjournment for discovery, to confirm that he was not planning on referring the defendant for competency. He refused to call me back, refused to answer my text. I got a call from him this morning at 8:30. It was the first time he has spoken to me since pre-PCC last week. And that is when he told me that he had not spoken to his client, that other members of his team had fortunately stepped in to speak to his client for him, and that they were concerned about his competency, and that he wasn't sure if the defendant would be able to sit through with this hearing today.
This is totally unconscionable.
Which I told Mr. King that we would address the, because to be fair, Judge,
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. Clear? Counsel? Clear? Answer my question. Clear? Make sure he brings a toothbrush when he comes for his show cause. Thank you.
if I may, Judge, I recognize I have no actual power to object to a competency referral. And I recognize that. But the way that this was handled, it is one thing to inconvenience me, and I have a lot of respect for the Neighborhood Defender Services. There are several of them here at this courthouse that I have so much respect for.
Me too.
But how this was handled was completely inappropriate, and I told Mr. King that until there was an actual issue in court, we were here, we were ready to go, and I'm at a loss, Judge, because ethically as a prosecutor, I know that I cannot push to proceed when there is a genuine referral for competency. I don't want to compromise my ethics, but this is extremely difficult for the position that we are in, and the reason we're in this position is because of Mr. King.
If I may, Your Honor. Yeah.
Go ahead.
Well, thank you, prosecutor, for the procedural history, and I can't speak to the conversations of the prosecutor had with Mr. King directly. However, I will remind or just say that at the times and moments that Mr. King was stating that he did not intend to refer to company until after buying over, that those were true statements, and it wasn't until understanding the actual, and not to get into privileged communications and client confidential conversations that we've had, that even at this preliminary examination, even if it is probable cause, and even though he's told the prosecutor that we don't intend to refer to competency until later, it was clear that Mr. Littleton has an issue understanding the order, nature, and proceedings, as well as not being able to assist rationally in his defense. So it's not to say that Mr. King wasn't being honest or truthful, but
He was being lazy and unprofessional, counsel. He never spoke to the defendant.
Your Honor,
Unless she's lying to me, King told her he'd never met with Mr. Littleton. Other people from his office had.
I wasn't part of that conversation. I can't speak to them. I'm not
Then I'm going to take her at her word.
lying. Just saying that all the other times that she was speaking with Mr. King and he made the applications and the intention of holding this exam, that was his intention. It wasn't to be dismissive, he wasn't refusing to communicate, that he was figuring out.
Counsel, stop, or I'll hold you in contempt.
Just to make my argument.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from firsthand knowledge. She is. Sit down. Counsel, don't test me. Sit down. You're done speaking today.
Done speaking today?
Yes, ma'am. Who flew in?
Judge, the complaining witness in this case, her name is Nora Al-Thamna, that's spelled N-O-U-R-A, last name A-L dash.
All right, I'm going to want her in here in just a minute. Do the paperwork so we can send Mr. Littleton for his competency, which will be 6 months down the road before we hear anything. You guys can take Mr. Littleton back into lockup. Bring your complainant in.
Judge, do you want to come up?
Please.
Podium?
Just podium, yeah. Right here, ma'am. Right here. Did you tell her what happened?
I did not. I told her that there was an issue and he wanted to see her and that I would explain as instructed.
So we're not going to have an exam today. I wanted to apologize to you personally for making you show up and put you through this and have nothing of substance happen. I also want to know exactly, with documentation to counsel, what it costs you to show up here today. Because if I find the attorney in contempt, I'm going to charge him for your costs. You understand that? All right. I just wanted you to hear it from me personally that I apologize on behalf of the system. I apologize to you because the system is not treating you well. Thank you, counsel.
Brilliant.
Ms. Moore, anything else?
Thank you. And again, I just want to acknowledge that I do not believe that Ms. Farage did anything. She was just said.
I don't disagree.
I'm not threatening you. Say one more word and that's contempt. 30 days. 30 days.